what exactly is a basic structure? There are two interesting visions which compete with each other. One is the vision of Justice Matthew in Indira Gandhi's case, which Justice Khalifullah spoke about. And one is Justice Krishna Iyer's in Bhim Singh Ji's case of 1981, which dealt with a 9th schedule challenge. Justice Matthew felt that you must find the basic structure rooted in some article in the Constitution. It's not a principle hovering around like supremacy of the Constitution. It must find its place somewhere. Justice Krishna, on the other hand, said, no. When we speak of the great egalitarian principle, we are not speaking of Article 14. We are speaking of a principle. And that principle is what forms part of the basic structure. Article 14 doesn't. This debate has continued till date without much clarity. So, where does basic structure actually reside? I think we get clues from the preamble and from Article 368. Now, the preamble, you will remember, even though it's a preamble, it's the very beginning of the Constitution, was actually drafted at the end of the draft Constitution. Therefore, the framers really summarized what they thought were the principles that this Constitution laid down. And from it, you can cull out about 6 principles which one could call principles which really pertain to the basic structure. You have the first words. You have the fact that India is a sovereign democratic republic. Each word has in it some essential feature. The fact that it is sovereign goes along with the fact that the country is one, unity and integrity, which is the last part of the preamble. So you put the two together and what do you have? You have the fact that India today governs itself. It has thrown off a foreign yoke. So in that sense, it is sovereign. Second, it has chosen the democratic form of government. The democratic form of government believes in universal adult franchise, so that your representatives who govern you are persons who truly represent the adult population of the nation. What is the adult population of the nation is a separate matter. It was 21 years at the time of the Constitution, it is 18 years now, may become 16 years later. But the fact that we adult Indians rule ourselves is another essential feature. Third, the fact that we are a republic. A republic, again, is to say that we are not a dictatorship, we are not a monarchy. So, we are ruled by what may be called republican principles, closely allied to democratic ones. Here, of course, we have a president at the head. And as you all know, after Shamsher Singh, the president basically has very limited powers like the English king. We are governed really by a cabinet which ultimately is put in by the elected representatives who we as adult Indians vote in. So you have 3 concepts: sovereign, democratic, republic. You have 2 other concepts added by the 42nd Amendment of Mrs. Gandhi. Socialist, secular. According to me, they were wholly unnecessary. They were already there. Because the very next clause speaks of justice, social, economic, political. Social justice gives you a clue that we are a socialistic state. And therefore, every time the legislatures make laws, they will look to the welfare of the people generally, they will look to the directive principles and then make those laws. So socialism is part of social justice. Secularism equally is part of the next clause. Now the next clause is nothing more and nothing less than the cry of the French Revolution. Liberté, égalité, fraternité. And all three are mentioned in the preamble. So, you have liberty, which speaks of the liberty to express yourself, to think as you wish, and above all, of belief, faith, and worship. If you already have the liberty of belief, faith, worship, you are a secular state. Because the obverse of an individual having this great belief given to him as a fundamental right is that the state shall not interfere with it. Neither shall the state, as a concomitant, help one religion against the other. In fact, hands are off altogether. So you have socialist, secular inbuilt already. It was unnecessary, as I said earlier. Liberty is very important because it brings in individual rights. Because not only is liberty of faith, worship, etc., it is also of expression of thought in the most fundamental sense. So, you have both directive principles brought in by the preamble and fundamental rights brought in. We have not heard anything about property. In fact, Justice Hidayatullah, being the odd man out in Golaknath, thought it was a mistake to include property in the fundamental rights chapter at all. And it is his vision which was translated into action 11 years later by the Janta government by removing it and putting it in a separate article. Then we have a very important concept of fraternity. So we believe in unity in diversity, very important. Now I cannot be fraternal with you unless I know what you are all about. Very difficult. So it preserves cultural rights. You will find Article 29 of our Constitution is one of the few articles which doesn't find place in most other world constitutions. The right not only to preserve language, but the right to preserve culture. And it's an absolute right. State won't tinker with it, can't tinker with it. So it becomes very important now to realize that unity in diversity is equally, if I may put it that way, a part of an essential feature or the basic structure of the Constitution. And ultimately you end with dignity of the individual, which read with liberty, again brings in the fundamental rights chapter, divorce from property. So we have counted something like 6 or 7 essential features already from the preamble. If we go to Article 368 proviso, 3 or 4 more now come into being. The proviso speaks specifically of, as I told you, the executive power separated from legislative power, separated from the judiciary. And if you want to touch any of these, please go for ratification to the states. So you have separation of power which comes out of 3 of the sub-articles. You have independence of judiciary coming out of one of them, because if you wish to touch any part of the judiciary, as I have told you earlier, by amendment, you have to go again for ratification to the states. So you have separation of powers which has now emerged. You have independence of judiciary which has emerged. Then again, you have federalism which emerges. Because the moment states' representation in parliament is to be spoken of, or in any way, the legislative lists are tinkered with, which either curtail or add to state powers, you are touching a federalist issue. And last but by no means the least, the fact that you may amend the Constitution. And if you wish to change the manner of amendment, again you have to go to the states. Now, we have been able to cull out something like 11. My mathematics has never been good. 11 or 12 essential features from just a reading of the preamble and 368 proviso. We come back to the same conundrum posed. One by Justice Matthew on this side and one by Justice Krishnaiyer on the other. Are all these concepts somewhere in the air, or are they all grounded in the Constitution? According to me, they are grounded in the Constitution, but we must always remember that it is a Constitution that we are expounding. Chief Justice Marshall's most important words in McCulloch and Maryland. Never forget, we are interpreting a fundamental document, fundamental in all our lives. So principles of interpretation which apply to this document will be completely different from ordinary principles of statutory interpretation. Now, if we bear that in mind, and if we realize that we are not to be in the bark of words, so to speak, but that words themselves yield principles, then I don't think we have any difficulty in reconciling these two visions. You reconcile them by saying, yes, it has to be somewhere in the Constitution. It need not be in one article, it need not be in a sub-article, it may be in a cluster of articles, it may be at one end read with the other end. But ultimately, what you find from the words is principles. And if what you find is principles, then we have no difficulty. So if ultimately you wish to tinker with a principle, let us say of independence of judiciary, you will find it grounded in chapter 4 of part 5, which deals with the higher judiciary. You may find it grounded in 235 onwards, which deals with the high courts and the subordinate judiciary. So ultimately you have to ground yourself in some article or cluster of articles. And if you so do, then an essential feature emerges from principles. And if you want to tinker with any part of that essential feature, please beware. Keshavananda stares you in the face. Now, the other problem is, suppose you have something which does not or cannot be found in some article. Justice Khalifullah referred to supremacy of the Constitution. Where do we get this concept from? Not the Constitution itself. We get it from the fact that it is a Grundnorm, it's a basic document, and from the fact that it is above all laws. Please remember, the US Constitution has this grounded in it, Article 6, Roman Article 6, which says that the Constitution and the laws made under it shall be the supreme law of the land. We don't have any such article. So possibly basic structure is to be found not merely in articles, clusters of articles, but principles which can not only be culled out from the articles themselves, but also from concepts which are so obvious that somebody would say, of course, there's no question that the Constitution is supreme. So here now you have a third test. Now we come to the case law which followed after Keshavananda Bharati. You remember we've stopped midstream, so to speak, case law wise. We started with Shankari Prasad, we went on to Sajjan Singh, the doubts of two learned judges, Golaknath, the overruling of Golaknath, and then Keshavananda. Post Keshavananda, virtually the first case that came up was the Indira Gandhi election case. And something remarkable was done by the addition of the new Article 329 capital A. The Prime Minister and the Speaker, in simple words, were put above the law. In short, if there was a Prime Ministerial election or a Speaker's election, not only could no court go into it, but if a court had gone into it, no law was now to be applied in appeal. And 5 judges were unanimous in using basic structure to strike it down, though on very different visions. Chief Justice Ray's vision was perhaps the widest vision so far as the constituent body is concerned. He said, yes, constituent body is above Parliament, above the Supreme Court, above everything, above all the organs of the state, and can pretty much do as it wants. But ultimately, if it is going to set aside a judgment, which it can do, it has to apply law. And here, it was applying nothing. So therefore, according to the learned Chief Justice, the rule of law concept comes in. There was no law to be applied. Amendment bad, therefore, and violates an essential feature.